You're still under oath, Professor? Thank you.
That's good, please. Please, thank you, Melanie. Professor Derman, I'm going back to the third startle, the third sound.
Yes, my lady.
The accused never explained to you that he heard movement.
No.
Never explained to you that he heard the magazine rack move.
There was no description of the magazine rack moving it.
But he never explained to you.
He said it was the sound.
He never explained to you he heard movement. Now, am I right?
I can't remember.
But I mean, you were really interested in the sounds. You listened for him to explain the sounds to you. Am I right?
My lady, it was the magazine rack, which was I understood to be the sound.
No, you see, again, let's just deal with the questions. You were focused on the sounds when you spoke to the accused.
That is correct.
Now, I asked you a question. If he said he heard movement, you would have remembered that.
Yes.
So then, he did not say to you that he heard movement inside the toilet.
I cannot recall.
You see, it's the strangest thing. Cannot recall means it's possible I forgot about it, if I can't remember it. So I have to task you on it. Why would you use the word I cannot recall?
Because, my lady, that is the truth. I cannot recall.
But if he spoke about movement, it's the sound of movement, that was your focus, you would have remembered.
Yes.
So then we can really forget about the word recall. We could say to this court, he never said to me he heard the sound of movement. Am I not right?
It's like with a double negative. My lady, I didn't get that question.
Well, if you focus more on what I try and say and less on semantics, it would perhaps be easier. Let us start afresh. Your focus in your discussion with the accused was sounds. Am I right?
Yes.
You've identified 3.
Yes.
I asked you if he ever said to you that he heard movement inside the toilet.
No.
You say he never did.
He never did.
Okay. That makes the use of the word I cannot recall by you very interesting, because that indicates your bias for the accused. You don't want to give a straight answer. Why did you use the word I cannot recall?
Because I still cannot recall.
No, but you know he didn't. You just gave me an answer. He did not. Now you want to again go recall. Use the word recall. Why?
That's how it's been put to me.
No. You see, I will go through it again. I have an answer from you. Did the accused ever tell you that he heard movement inside the toilet? I have an answer, no. Is that still your answer?
My lady, Mr. Null has asked me this in many different spheres and over again. My first answer was, I do not recall. I can't recall. He asked me then, would he, if he did speak to me about movement, would I have remembered it? And I think that that is possible. I might have remembered it. But my memory is very fuzzy on this. I think that is quite clear to the court, that I am not certain. That's what I wish to say.
You see, I hear what you wish to say. However, I need an answer. If you, in the one instance, after I pressed you, if you're able to say no, why did you use the words, I cannot recall? That's all. Because you can recall it never happened.
My lady, I cannot recall it. I cannot recall it.
What can you not recall?
Cannot recall that he said there was movement. Do I recall that he said there was movement? No, I cannot recall it.
Just to test you, is it possible that he said that?
Suppose it is, because I can't recall.
You see, that is why, Professor, that is why I take you up on it. You don't want to give an answer that will not benefit the accused. You're too scared to say that he did not say that. Is that not so? Is that
No, that is not true, my lady.
Now, we will argue that the witness called by the defense, Mr. Wolmerans, indicated that the accused aimed at the door at least bullet hole B. He aimed, he had line of sight alignment when he fired that shot. Do you agree that he aimed for the door?
If that is what is put to me, I do not know any of Mr. Wolmerans's testimony.
But you won't exclude that the accused aimed for the door.
If that is what is put to me, I understand that.
You said so on Thursday as well. He aimed at the sound.
That is what I understand.
And on Friday, you went further. Thursday. You went further and you said, let me rather ask a question. Why did you fire at the sound?
To nullify any threat.
Okay. Now, he never identified a threat to you, what the threat was.
He told me he thought there was a burglar in the toilet.
He told you that.
Yes.
Did he explain the third sound, what he thought that was?
He said that was the magazine rack.
He never said that. He said it was the burglar bumping against the magazine rack.
No, he did not say that.
He never said he thought it was the door opening.
No, he did not say that.
Okay. Professor, I have put to you, and I do it again, that you are not objective in your evidence before court. Do you want to respond?
My lady, I have responded to that. I acknowledge I've been in a position of care to Mr. Pistorius for a period of 6 years, and that indeed I've served as his physician, and that I have attempted to come to court to give as an objective opinion as I can. I have backed up whatever I can with scientific evidence And according to my obligations as a medical practitioner, I have given the best possible evidence that I can. I do not think that I am biased. I believe I have given an objective opinion.
I put you that based on the accused version, if the court would accept the accused version, not the state's version, the accused version, you understand that?
Yes.
He, with intention to kill, shot the person behind the door. That's what he wanted to do, and that's what he did. Do you want to comment on that?
No, I understand that.
Is that all? You want to say understand it? And
Yes.
I put to you that your evidence in no way affects his intention on the night. You have no comment?
But is it my job to do that? Is that not the court's job to do that?
Do you want to respond to what I just put to you? Yes or no? You're an expert, sir. You can say, I don't want to respond, that's fine.
From what I understand, my lady, it was his intention to shoot. That's how I understand it.
I've nothing further. Thank you, Lady.
Thank you, Mr. Nell. Yes, Mr. Oldwage.
Thank you, my lady. My lady, I'm going to deal with two questions, whereafter I will ask for a short adjournment of 5 to 10 minutes
Yes.
to consider my position. Professor Durman, with reference to the concept of vulnerability coupled with anxiety, can one compartmentalize the existence of that condition into particular circumstances? And I'm going to explain to you what I mean by that. It was put to you that on the evening of 13 February 2013, Mr. Pistorius was, as Mr. Nell put it, not anxious and was relaxed. Do you recall that?
I remember that.
Now, particularly with reference to that which had been put to you, I ask the question, can you compartmentalize when a person is anxious and fearful in accordance with various times or experiences in that person's life? In other words, does that person just become less vulnerable, less anxious when he's relaxed?
No, because there are two recognized constructs of anxiety. There's state anxiety and there's trait anxiety. State anxiety, my lady, is our situational anxiety that we find ourselves in response to certain surroundings. Your trait anxiety is your genetic susceptibility. It's your genes and how we are as individuals because of our makeup.
The second question also relates to what Mr. Nell put to you, that being, hypothetically perhaps, that on the morning in question, our client could simply have walked away. Does that approach fit with what you've described as the fight and flight response?
No, it does not fit that description.
Please explain why not.
is because there is, if one believes that there is a significant perceived threat, one is not going to simply walk away from anything. There is going to be, as rapid as possible, a flight, if that is possible. If one believes, however, that the perceived threat is going to overwhelm you and run much faster than you and actually catch you and harm you, then the fleeing and the flight is not possible. Then we are left with only a fight response.
Thank you, my lady. Might I now ask for the short adjournment?
How short?
5
How
to
short?
10 minutes. We'll notify as
10
soon as we're
minutes,
ready. It shouldn't be more than 5 minutes. Thank you, my lady.
We'll take the agenda. You're still under oath, Professor?
Yes, my lady.
Thank you. Thank you, Mr. Aldridge.
Thank you, my lady. I have no further questions for Professor Durban.
Professor Derman, thank you very much for your assistance. You may be excused.
Thank you. Thank you.
Yes, Mr. Wu?
Thank you, my lady. My lady, this is probably the last witness. We just need some discussions, and we need just to have a discussion with Dr. Kotze. We have not consulted with her before. She's present today. So I think that's an opportune time. May we stand till 2 o'clock just to make sure that we do not call further witnesses?
May I, my lady, whilst I'm listening to what Mr. Roux is saying, Dr. Kotze is clearly the state's witness, a state psychiatrist. I do not see how Mr. Roux now intends consulting with the state psychiatrist, if that is what he's saying. I don't understand that. So perhaps we should deal with that before we now stand down until 2. I mean, there's a defense psychiatrist, state psychiatrist, a court psychiatrist.
I didn't realize that. I'm sorry. Yes, Mr.
Lady, it's not a state witness. It was the psychiatrist appointed for the state,
For the
psychiatrist appointed for the defense, and one
Yes.
for the court.
Yes.
It's not a state witness, and we're entitled to consult. It's not a state witness. It's just the one that's part of the panel. They brought out a report, and we're in a position.
Just give me 1 minute. I haven't seen 3 separate reports.
It's only one report. That's why.
Yes.
And we just need to sit down with her and get some understanding. We've done it with Dr. Fine, and similarly we want to do it here. It's not a consultation with a state witness. We don't, when it comes to Section 78, it's not your witness. It's a panel appointed by the court, one on behalf of the defense, one of the state. It's very different to a state witness.
I don't agree. The defense consulted with their psychiatrist, which is Dr. Fine, but the state wasn't there. We weren't invited to it. Now the defense wants to consult with the psychiatrist appointed by the state. Why would the defense have a right to consult with a psychiatrist appointed for the state? Would they also have a right to consult with a psychiatrist appointed for the court? My lady, may I take the court back to Mr. Aldridge making it apparently clear? He wanted to know exactly who I'm consulting with, because he said we should not consult with their psychiatrist or the court psychiatrist. That was the intention of the question. Now the shoe's on a different foot. My lady, it's not as if the defense does not have a witness. They do. Dr. Fine. They've indicated to you now they've consulted with him. They must take their decision to call him or not. They cannot, my lady, have a bite at every panel member in consultation before they decide who to call a witness. And certainly, my lady, not with the psychiatrist appointed for the state.
Yes, yes.
There are 2 main difficulties in the state's proposition, if I may explain it. One, let's go on a pure approach of a state witness. Then there's Shabalala's case. It's very clear. Then the state can be present. I have a right to consult, and the state can be present. That's the first point. There's one more important point flowing from that. Assuming again, and the best argument by the state, that it's a state witness, then he must tell us he's calling her or not calling her. And we know the rule. If you don't call state witnesses, Mr. Nslengethwa, Mr. Rika, Mochwane, then we can call them. And we ask the state to tell us if he's going to call her And that's only on a pure state witness approach. And if he doesn't call the witness, then that protection is in any event not there. It's in any event not there in Shabalala with the one proviso, then the state can be present during consultation. But if it doesn't call that witness, then we're entitled to consult with that witness and decide if we want to call the witness. It works with every state witness the same way, unless they're called by the state. And that is ample case law on that. So the state cannot call a state witness and then say, I'm not calling her, but you cannot consult with her. And that's why we asked before. Unless he tells us that he wants to call her, then it's very different. Then we'll sit back. But if he doesn't call the witness, then we want to consult, because then it's open for us to consult.
With that, Mr. Respect, my lady, I don't agree. But what I'm willing to say is, if the defense calls another witness, and that witness is Dr. Fine, in all probability, I'll call Dr. Kotze. It's not, will I call her now? No. The answer is, as I'm standing here, I have to convince the court, firstly, to call this witness. I will do that at the end of the defense case. I don't know if we've reached the end of the defense case. I cannot, my lady, it's impossible for me to get up now and just call a witness. I will have to ask the court's leave to call a witness. But what I'm willing to say is, my lady, if the defense calls Dr. Fine, if they call Dr. Fine, in all probability, I will call Dr. Kotze if there's a need. So it's not as easy as Nglingetwa and those people, my lady. The fact is, we both, Mr. Roux and I, indicated to the court that we accept the reports. We've done that. Based on that, the defense do not have a right to consult with the state psychiatrist. My lady, it is just a matter of fairness even to everybody concerned. Each person, each entity had a witness appointed. Defense, state and court. Why would the defense, my lady, have a right to consult with them all before they call them? It doesn't make sense. The court cannot order it, my lady. What the court can do with the utmost respect is the court can indicate that there was a psychiatrist appointed on behalf of the defense. They should make a decision to call it or not, because I'm placing on record. If they call Dr. Fine, I will use Dr. Kotze. I may not call her because I don't know what Dr. Fine will say. But if there's something there that I don't agree with, in all probability, I will call Dr. Kotze. As a court, please.
Okay. Mr. Roux, is there precedent for what you're asking me to?
Yes, my lady, I can get many precedents. The fact is that the state cannot say, if I can come back to the principle. When there are state witnesses, the state takes statements of many number of persons. Every person not called by the state in the state's case, the defense is entitled to consult with and decide if they want to call them. It's happened in this case. We called the neighbours. They were all state witnesses. It could never be denied by the state. At the moment the state closed this case, the witnesses become available. That's the rule. That cannot be in dispute. Now what we have, we come to the end of the case. I'm not calling Dr. Fine. Before I close my case, there's another person that may or may not be a witness that can be called. We don't know. We haven't consulted with the witness. We asked the state, of course, if you call that witness, then we'll sit back. And we can only cross-examine. But if you don't call that witness, we have a right to that witness. The state, otherwise, if it's not so, what the state can do is to get many statements from every possible person, only call 5 persons, and say the rest are protected.
But we are talking in particular about an expert who was appointed for the state.
That's what I was saying. I say in the first place, as a panel member, there can't be an objection that we consult with her. If the state wants to make a position that's exactly the same as a state witness, it's in any event available. But We cannot be denied to consult with the witness unless the state indicates to us that he's calling the witness. He says, well, if you're calling Dr. Fine, then I may want to call her. We're not calling Dr. Fine. Now, if we block to consult with a potential witness that the state's not calling, I mean, that would not be fair. There's no basis to stop us on that.
Yes. And you said there are precedents. Any case in point?
Any case in point on a state witness not called by the state?
No, I'm not talking about that.
I don't know of any case saying that if the state does not call a panel member, I don't know of any case dealing with that specific. It's a principle.
Yes.
So I would be wrong and say there's a case that I can rely on at that point. The case laws, if the state does not call a witness, that witness becomes available. So if the state tells me it's a state witness and it doesn't call it, that witness becomes available. It's that principle. But I don't know. There may be, but I don't know of any case, my lady.
What I saw was one page of the report. Did council have access to a full report?
Yes, my lady, there's the one page by a psychiatrist, and then there's a full report by a psychologist.
No, I'm not referring to the psychologist.
Yeah. No, to the psychiatrist. Yeah, it's one page, my lady.
One page.
But, my lady, and it's on that we want to consult. It may not be one page that's only relevant.
That's why I want to know, have you had access to a full report?
No, my lady. It's only that one page. And that's why we need to consult to understand. It's for that very reason.
But there must be a full report.
I don't know, my lady. I
You
would be
don't
wrong in
have an
answering
idea.
you. I'm very careful to make a wrong
Yes.
statement. I don't know. All we have seen was this, and that's why on that report we really need information. Not to say that we will call the witness, but to understand, is that a witness that we should put before the court? Would there be anything flowing from that we must look at or not? We simply don't know. We know it's very relevant, but we don't know how far it will go, if it will go that far, in the absence of that full report. What we do know, if I may assist the court, the only protection is there that it's the accused version to them that's protected, that's privileged. And that's not what we're going to. The Act makes provision, Section 79 makes provision, that's protected for just reasons to put it before the court, as through the back door. But that's not what we're asking for. We're not interested in the accused version. That's the only protection that's in the Act.
Mr. Nell, you want to say something before I...
No, my lady, as far as access to reports concerned, that is the report. The one page is the report.
That is the report.
Yes. My lady, am I entitled just to address one point that Mr.
Yes,
Root
yes,
just
yes.
made? If it pleases the court. My lady, we're not dealing with a normal state witness by saying, I'm not calling fine, I want to consult with your witness before I close my case. That cannot happen. But my lady, the process is the following. On behalf of the defense, they elected to appoint Dr. Fine to the panel. There was a finding and all three psychiatrists agreed with the finding. So that's a fact. Why would there be a need to consult with a different psychiatrist if you have your own? My lady, if there was something, if Dr. Fine was not available, then we'll wait. But there must be a reason why we don't want to call Dr. Fine. We would rather consult with the state's witness. We would rather have the state psychiatrist. My lady, what's next? Can we now consult with the court psychiatrist? And why is that application not made? And when will that come? It's not an instance, my lady, with the utmost respect, where there is no defense psychiatrist. There is one. He is available. He consulted with the defense. My lady, the state psychiatrist is available for the state to assist the state should the accused attack the findings and or call people. The defense cannot consult with everyone and then decide what they want to do. That is inherently unfair. It's not a normal instance, my lady, where we deal with a state witness. That I agree. It's something different.
Thank you very much. What's the time? I think we'll take a few minutes adjournment.
As the court pleases.